Hi guys, today we are going to discuss about introduction and rules of mobility allowance. First of all, we will discuss about introduction. Mobility allowance was a means tested monthly payment payable by the Health Service Education HSE to people who are aged 16 and over the underage 66 and who have a disability and are unable to walk or use public transport and who would benefit from a change in surroundings. For example, by financing the occasional taxi journey. There is no specific legislation providing for mobility allowance. Instead, this allowance was introduced in 1979 by the Department of Health and is payable under Section 61 of the Health Act 1970. In 2013, the Department of Health announced that the Mobility Allowance scheme was closed to new applicants. An alternative scheme is being advised to replace it. This alternative scheme will be called the Transport Support Scheme. In the meantime, the HSE continues to make monthly payments to people who were getting the mobility allowance at the time that the scheme closed. Now we will discuss rules. The mobility allowance scheme is now closed. The following rules applied when it was operation. You are eligible for mobility allowance if you meet the following conditions. Number 1, you are unable to walk even with the use of artificial climbs or other suitable aids, or your health is such that the exertion required to walk would be dangerous. The inability to walk must be likely to last for at least a year. You must not be medically forbidden to move. You must be in a position to benefit from a change in surroundings. You must be living at home or in a long-term institution. You must pass a means test. The decisions on whether or not you meet the medical criteria is made by the HSE Senior Area Medical Officer for your area. Now we will discuss about assessing income. To determine the amount of mobility allowance you will receive, you calculate your total assessable income. Some income is not assessable. In the case of a couple, both your incomes are added together. Any amount in excess of the appropriate weekly social welfare payment for your family is deducted from the maximum amount of weekly mobility allowance payable to you. The appropriate social welfare payment is disability allowance where you are under age 66 and state pension non-contributory where you are over age 66. The appropriate weekly payment depends on whether you are a couple and have dependent children or not. To calculate the maximum weekly mobility allowance, you multiply the monthly rate by 12 and then divide by 52. In the case of a couple where both of you are eligible, half of any amount in excess of the appropriate weekly social welfare payment for your family is deducted from the maximum amount of weekly mobility allowance payable to you. Now we will discuss non-assessable income. The following payments are not taken into account in assessing your means. Blind welfare allowance, child benefit, domiciliary care allowance, foster care allowance, higher education grants, national fuel scheme allowance payments, living alone allowance, over 80 allowance, supplementary welfare allowance. Income up to maximum amount approved by the Department of Social Protection DSP from employment of a therapeutic or rehabilitative nature. Monies received from charitable organizations other than remuneration. Special compensation to awards that are extremed by legislation, for example, thalidomide. Travel and meal allowance paid to participants on government approved schemes. Repayments received under the health Repayment Scheme Act 2006. The benefit of the Disabled Drivers and Disabled Passengers Tax Concessions Scheme. Now we will discuss carers payments. If your spouse, civil partner, cohabitant is receiving carers allowance or carers benefit, the payment is ignored. Instead, your income is assessed by being your primary payment plus any increases for qualified children plus the supplementary welfare allowance increase for a qualified adult. Where carers allowance or carers benefit is paid in respect of you to someone who is not your spouse, civil partner, cohabitant, it is ignored that and you are assessed on your own assessable income. Capital. The formula used in the assessment of the income from capital is the same as that used by the DSP in the means test for disability allowance. Motorized transport grant. If you receive a motorized transport grant having previously received the mobility allowance, you will no longer receive the mobility allowance. This is because the payment of a motorized transport grant is subject to the condition that the HSE will not be called upon at any future date of contribute towards the running costs of the vehicle. You will not be eligible for the mobility allowance again until 3 years after the date of payment of the motorized transport grant. Appealing the refusal of mobility allowance. There is no statutory appeal. There is no statutory appeal scheme for mobility allowance. In other words, if you have been refused mobility allowance by your local health office, your right to appeal is not set down in law. Where an applicant is refused, the HSE will formally notify you of their decision and include details of how to appeal this decision. Appeal procedures for mobility allowance can vary from one local health office to another. Some local health offices, for example, will conduct a review hearing where independent senior medical officers will meet the applicant and review their applications, including the medical evidence. Other local health offices may refer the appeal to their appeals office for review. Contact your local health office for information on the appeals process in your area. That's all. Thanks for watching the video and don't forget to subscribe my channel. Thanks a lot.